So when we're thinking about what makes somebody available for employment, we have to consider the geographic area in which they are living as to whether or not they would be eligible or would reasonably want to apply for the job at your company. So minorities and women in a particular geographic area who are qualified were considered to be available for the particular job. Now, where we recruit from has to do with the type of job, the type of skills that we're looking for, and the level at which that position is in the company. And lower level skilled jobs tend to recruit usually within their local area, usually within a couple of towns, something that's reasonable, like no more than maybe a half-hour drive for somebody. Maybe that's even too much, but nonetheless. So we want it to be within a particular area that is reasonable for the level of skill that we're trying to hire for. Now, the further up we go the ladder in terms of the higher position in the company, we might expand our recruiting area to include people in St. Louis, right? Now, the local McDonald's in Edwardsville is not necessarily going to hire somebody who lives in St. Louis who's going to take a car and drive over the river and come here to work at McDonald's. I mean, that's certainly possible, but that tends to not be where we recruit from. And so the same thing as we go higher and higher up the hierarchy, we expand our geographic area because the probability of finding somebody with the more expansive skill set that we need will require a larger geographic area to be able to find those people. So, for example, if we're hiring a chief marketing officer or a chief HR professional, we could potentially have a national search for somebody, depending on the size of the company we are. Probably a smaller company is less likely to do a national search, but a big company like Hortica Insurance or AB InBev or Bayer slash Monsanto, they would be far more likely to recruit nationally for senior level positions. And then a CEO position could certainly be locally recruited, but it also could be nationally recruited, and it also could be globally recruited. So it really depends on the job, the skill set we're looking for, the size of the company. There's all sorts of factors that go into what is considered to be a reasonable geographic area for when we're involved in recruiting. So we want to first then look at the percentage of women or minorities in that reasonable recruitment area to determine whether or not we have adequate number of individuals in our organization as compared to what the local available labor market looks like. And so we're going to make that comparison. Next, we want to look at inside my company who is promotable, who is transferable, who is trainable within the company, because they become the internal labor pool that we have specifically for our hiring opportunities and promotional opportunities. In terms of placement goals, recall that quotas are forbidden under the Civil Rights Act of 1991, and we'll get more to that as we talk a little bit later. But fundamentally, quotas where we decide we need to hire 5 more women and it's a mandatory thing. A quota is required. A goal is something entirely different. A quota means we absolutely must hire these individuals. It's a requirement, and that is considered illegal. Setting a goal is very different. Setting a goal to increase the representation of underrepresented groups is about making a good faith effort in your particular geographic area to attract more people to your organization to be able to improve the diversity in your organization. And so we set goals, we set aspirations, we set intentions, and we engage in activities by making a good faith effort to increase the diversity in our company. So these plans need to be very action oriented when we're thinking about what our plans should be. And again, it's not about saying we must hire 5 people to fill this position. and more be focused on, we are going to start recruiting from Howard University in their engineering area so that we can increase the number of Black engineers who work in our company. So that's a goal, to increase the representation of Blacks in the area of engineering. And so you want to make all good faith effort. That's the standard that we're held to, a good faith effort. A good faith effort basically means that we are trying our best in a proactive, affirmative way to improve the recruitment pool of the applicants that we have, and that is our goal. Corporate management compliance evaluation basically means that we are obligated to evaluate how people are advancing in the company and whether or not there are any barriers or glass ceilings, if you will, where these mid and senior level employees are not getting, if they're not getting opportunities to grow and advance in the company. So we need to make sure we're looking at our corporate compliance in terms of advancing and allowing managers to advance to higher levels in the company. The Office of Federal Contract Compliance Programs conducts audits of our plans to ensure that we are adhering to our plan. So it's not enough to just say, I'm going to put this plan in writing. You actually have to actively go after and initiate the plan. And so you have to show that you are making that good faith effort to identify and remove the barriers for equal employment opportunity, to expand employment opportunities, and to make sure we've got good metrics that are measuring the results that we want. Again, the standard is a good faith effort. And so it doesn't mean that you just put it in a plan and then forget about the plan later on. So you have periodic internal auditing that has to occur, so that you need to make sure that you are doing the plan, and then they will come in and also audit your plan. And then you want to have regular reports to upper management on how well you are doing in terms of achieving these outcomes, because OFCCP is going to want to know this information in order for you to stay compliant for contracts. The appropriation of the activities have to be related to the problems. So it's one thing to say, we've got all these great activities. Look, if you're not having a problem attracting certain groups, then then you don't need to have a plan in place to attract those groups, right? Your plans will be changing regularly on an annual basis, very likely, as you improve and you hit your goals and you are seeing more diversity in your organization. You're going to be very likely to need to maintain the levels that you're at, but you may not have to engage in affirmative, proactive action to necessarily increase those numbers any more than they already are. So it is important that we make sure that we are engaging in activities that are related to the goals that we set. We don't want to be engaged in activities that are unrelated to the affirmative action goals that we want to have in place. The OFCCP can institute penalties for non-compliance. So if you are not complying and engaging in affirmative action when you're required to, if you don't have a plan in place, and if you are not proactively engaging in attracting qualified women and minorities to your organization, they can come after you and they can penalize you with all sorts of fines for every violation that you have. So they will publish the names of non-conforming contractors and labor unions so that if it's open to the public, so if I'm looking to hire a contractor myself, I will know whether or not this is a contractor that has a history of discrimination and is not in compliance with EEO 11246. They can also recommend Title VII proceedings to the EEOC or the DOJ if they see a long history of noncompliance and a long history of discrimination. So that means that now the case goes to the EEOC or to the Department of Justice to say, we have a contractor who's in violation of their contract and in violation of this executive order, and they need to be penalized. You can request a DOJ suit to enforce the executive order in cases of actual or threatened violations of the EEO clause. So what that basically means is if you have an organization that is actually violating the clause or is threatening to violate it by not adhering to the executive order, you can go right to the Department of Justice to have a legal action against that organization. They can recommend to the Department of Justice that criminal proceedings be initiated if you provide false information. So that's important that you make sure you are not providing false information. And they can also cancel, terminate, or suspend a contract, even in portions. Now, again, that's rare, and it is rare for companies to absolutely refuse to do affirmative action. I mean, if you're going to engage in contracts with the government, you know this is something you're going to have to do. So very likely, instead of canceling or terminating, they're going to penalize you. They're going to charge you, and they're going to, perhaps you may lose some aspects of your contract, but that's rare. As I said, losing the contract is rare. OFCCP must make a reasonable effort to secure compliance through all sorts of tools. The goal is not to go right to the high-end punishment to cancel your contract. The goal is we sit and we meet, we sit and we talk, we sit and negotiate, we persuade, we engage in other behaviors to see if we can get the organization to comply with the contract compliance. And then if all else fails, we can go to a DOJ, Department of Justice criminal proceeding. We can also remove the contract if we want to. But that's not where we start with. We start with trying to conciliate, trying to make an agreement that's going to work between all the parties. Judicial affirmative action is not related to Executive Order 11246. And in fact, it has nothing to do with contract compliance. You can be an organization that has a long history of discrimination, and as part of the ruling in the courts can require the organization to engage in affirmative action. Again, proactively attracting women and minorities and underrepresented individuals to their organization to remedy a long history of discrimination that has occurred. And so it is unusual, and there's not always a specific regulation that states that they have to do this. But it is important to note, again, that quotas are not allowed. And that was part of the University of California v. Bakke, which is considered a quote-unquote reverse discrimination case. I personally don't tend to like the concept of reverse discrimination, because discrimination is discrimination. You're either making a decision based on race or sex, or you're not. So it's still a form of discrimination, whether it's reverse or whatever you want to call it. I don't like the term reverse discrimination, so I don't tend to use it, but you may see it, written in some locations. What we're implying when we're thinking about reverse discrimination is that we're discriminating against the majority group. The majority group claims to be discriminated against, that they are not being hired or enrolled in a program like the University of California. Bakke had applied for medical school, and he was not accepted, and somebody of lower quality was accepted into the medical school. And the medical school was arguing that they needed to have a quota of a certain number of minorities in their medical school. And that case basically argued, no, you cannot have quotas. Quotas are not allowed. Another case is Local 28, the sheet metal workers versus the EEOC. There were severe, specific requirements to address union recalcitrance regarding orders to ensure that they were not discriminating against union members and union policies. So another example you can see also is in scenario 1 in the beginning of this chapter, so you can read that there as well. The last category is voluntary affirmative action. Any organization, any employer or union can adopt an affirmative action plan all on their own, compelled by their own self-interest and not by the executive order or any judicial court order. So what they're doing is proactively, affirmatively, voluntarily trying to figure out how to address the imbalance in the underrepresentation in their organization to avoid discrimination charges. And so every organization should actively and proactively being engaged in voluntary affirmative action to ensure that we're not discriminating against underrepresented groups in our organization. That's important. And scenarios 2 and 3 in your textbook get at some voluntary types of affirmative action programs.